So, Mr. Lal, have you been able to satisfy his grievance?
My lord, we have already, my lord, done whatever is required to be done, my lord, for satisfaction of his grievances. My lord, he has not been able to point out that on what count, my lord, he is saying, because, my lord, his confusion is only regarding the relief of the amount which we have extended in his favor. Now, he says, my lord, that 2,81,737, which is, my lord, calculation of 89 subsection 1 relief. He says, my lord, on that, my lord, interest has to be calculated. That relief, my lord, has already been extended to him as per his own documents, my lord. Because Form 10E was filed by him in the year 2013. Along with, my lord, for Form 10E, he has also, my lord, submitted calculation under section 89(1) for spread over, your lordship. That has already been extended, my lord.
Just a minute. We had asked our chartered accountant to submit a report.
Sir.
What is that report?
My lord, that report,
High Court's chartered.
that report, my lord, I have got.
आपको कॉपी मिल गई है उसकी? वो कहाँ है रिपोर्ट? डेट क्या है उसकी?
That is dated 14/9/22. सर उन्होंने देखी चार्टर्ड अकाउंटेंट ने हमारी दोनों चीजों को एक्सेप्ट कर लिया है सर. चार्टर्ड अकाउंटेंट ने हमारे अपनी रिपोर्ट में, अगर आप सर लास्ट में आते हैं, hence the calculation of interest can be done as follows.
एक मिनट, कहाँ पढ़ रहे हैं?
Sir, I'm reading, sir, at the page number 2. There are only 2 pages, my lord, of that report. Page number 2, my lord.
अलग से लगाइए क्या?
Calculation with reference to amount specified in WP 10787/2022. Reference communication dated C/4556 dated 9/9/2022. Respected sir, we have gone through WP number so and so, specifically annexure P10 of the said petition, being decision of the coordinate bench of this court rendered on 14/2/2019 in WP number 9424 of 2017. And consequently, we have come to an understanding that the sole matter involved is regarding the rate of interest on refund amount of rupees 205030. Now, meaning thereby, your lordship, he has accepted that the amount on which, my lord, the interest is required to be calculated has been rightly calculated by the income tax department. That is, my lord, 2,05,030. Now, in order to ascertain the rate of interest applicable in the present case, Section 244A of the Income Tax Act is pertinent. Relevant extraction of the section is reproduced as under. Now, my lord, it is only a reproduction of the section. Now, kindly, my lord, turn down to page number 2. Thus, as per Section 244A of the Income Tax Act, following inference can be drawn. Present refund is out of TDS, which is to be treated as paid under Section 199. Simple interest is applicable on refunds. Interest at the rate of 0.5% month is payable. Now, my lord, it is the answer of his third query, where he was claiming 1.5%, my lord, interest. So the answer is, my lord, that only 0.5% per month is payable, my lord. And this has also been accepted by chartered accountant. Now, fourth one, my lord, interest is payable from the date of return filing, that is 27/10/2010 in the present case, till the date of refund is granted, being 29/4/2019, and part of month to be treated as full month for the purpose of interest calculations. Hence, the calculation of interest can be done as follows. Duration for the purpose of calculation 102 months. Interest on the amount, my lord, which we have calculated to 2,05,030. That is, my lord, at the rate of 0.5%, 1,04,565. Hence, as per our calculation, interest to the tune of rupees 1,04,565 is payable. Now, kindly see, my lord, what we have calculated and why he is, my lord, raising objection to that. Yes. Your Lordship, the
Your otherwise reply is there.
my lord, kindly see, my lord, this we have calculated. He is annexed, my lord, along with his WP 10787 of the 2022, annexure P1.
Which para?
Yes. My lord, kindly see the annexure P1, whereby, my lord, his query regarding that how much he is entitled to get, my lord, that was, my lord, being done by letter dated 23/5/2019. Yes. हमने ज्यादा पेमेंट कर दिया है सर.
No interest.
If your lordship will see this letter dated 23/5/2019, the calculation, my lord, is given at page number 13. As per, my lord, his annexures, my lord. Now, the refund amount is absolutely equal to what this chartered accountant has calculated, my lord. That is 2,05,030. Total refund, my lord. My lord, page number 13 of his, my lord, petition.
What is your submission with regard to para 6.5 of the petition?
Ji?
Para 6.5 of the petition. What is your submission regarding that?
There was 6.5.
Because this is the ground why he is claiming interest at the rate of 18%. And this point has not been discussed by our.
No, that has been discussed. That has been discussed, yes. We should not say, my lord, that it has not been discussed. Kindly see, my lord, at page number 2.
Page number?
Page number 2, my lord, of the report of the chartered accountant. It has been discussed, your lordship. He is saying, my lord, that it should be 1.5%.
What is your submission?
Chartered accountant says, my lord,
Where?
kindly see the, my lord, column number 3, sorry, my lord, paragraph 3, page number 2.
Yes.
Interest at the rate of 0.5% month is payable.
That he is mentioning the section. The section prescribed that interest
Yes,
will
yes,
be
yes.
0.5.
Yes. Yes.
I mean, the claim of the petitioner is that it has to be a penultimate interest
Parity to what?
in 6.1.
Yes, parity to what, sir?
6.5.
Sir, parity to the section can be extended. Parity as per the sweet will and whims of the petitioner cannot be extended.
I am saying what is your submission on that?
Sir, sir, we have calculated. Sir, if my lordship will allow me, my lord, to complete my submissions.
Yes, please.
My lord. My lord, kindly come down to, my lord, that annexure P1. Because, my lord, now an expert report is also there on record, your lordship. Now, once expert is saying, my lord, that what calculation has been done by the income tax department, it is absolutely correct, your lordship. And what we have paid him, my lord, that is exceeding, my lord, the amount which has been calculated by the chartered accountant. Now, kindly, my lord, come down to page number 12.
Page number 12, P1.
Page number 12, P1 of the petition.
Yes.
Every, my lord, contention raised by the petitioner has been answered, my lord, in this. If my lords will permit me, I will read, my lord, from this. In compliance, my lord, may I read, your lordship?
One. Yes. Oh, yes.
P1, your lordship.
Yes, yes.
In compliance of Honorable High Court Jabalpur order dated 14/2019, in your case, the refund of amount is rupees 3,13,680. Has been issued on 25/4/2019. That has already been paid, your lordship. This refund was processed in compliance of order under section 154 of IT Act 1961 dated 5/12/2014. Now, if your lordship will, my lord, check out the order which was passed in WP 9494/2017. In paragraph 34, Honorable High Court has directed that whatever calculation was done.
What I am saying
No,
that
no, let
all
us.
the points are not covered in this report.
Which point?
Lordship, I am reading second part,
Order dated?
29/8/2022.
Yes.
After hearing petitioner in person and Sri Lal learned for such standing counsel, This court is of the considered view that since the matter pertains to income tax and deals with various provisions of the Income Tax Act, including provision regarding grant of relief under Section 89(1) of the Income Tax Act, it would be appropriate to seek opinion of an expert in this field. Lordship said thereafter. The sole question which arises is that after the decision of the coordinate bench of this court is rendered on 14/2/2019 and WP number so and so, wide and except P10, where the amount of total refund is 2,05,030 and interest over the same amounting to rupees 1,08,650 held to be payable by the revenue is the correct figure as per law or not. Again, the petitioner claims that the principal amount ought to be 2,81,797 instead of 2,05,030. Now, as per this order, 3 points has been raised. That is, first is Section 89(1). It is to be explained. Second, whether the petitioner is entitled for 281 or 2,05,000. I am demanding 281. They are giving me 2,05,000. On that point, the report is silent. On 81(9) section, the report is silent. They have given only arithmetical calculation on section 244. And I have challenged that 244 is not applicable in my case because I have got the refund by order of this honorable court.
No, the
which is
difference,
covered by
this difference which is coming is only because of the rate of interest.
rate of interest.
There,
Rate of interest and amount of refund also. They have taken the basic amount as
5,000 is it there in the ITO's order? Because in the earlier round, they had said that whatever has been given by the ITO, that will, whatever benefit is there, that will flow to you.
Lordship, kindly see and
This
examine.
is, you come to,
No,
Page
on
20.
the previous round of litigation, please.
no, we cannot go behind the previous round. This
No,
is,
no, no,
this
I
is.
have not gone behind the previous round.
नहीं, आपका जो
Because
petition है,
he have also quoted the previous round.
आपका
Kindly
जो,
see and exhibit B7.
आपकी जो petition है, वो more or less is like an execution application of the earlier round.
No, no.
That you want to implement that.
What the Honorable High Court has said in previous order, that has been not complied by them.
तो
Kindly see and exhibit P7.
जो previous order है, वो उसमें क्या कहता है वो? It is directed that petitioner is entitled to and shall be paid his dues mentioned in the order dated 5/12/14 of the ITO
Lordship.
within 2 months. Now,
Kindly see and exhibit P7, where they have refused to give me the refund entirely. Given
no, first we have to come
No,
to
no.
the ITO's order.
No,
ITO ने क्या बोला है?
ITO order is 512.
हाँ, page 20, 26,
Lordship.
27.
That is an exhibit P6.
Yes.
Page number 25 to 27. Lordship, there no amount of refund has been paid by the income tax authority, IT officer. He has taken the gross amount only. That is 20,90,355. And after rectification, it becomes 20,87,089. No amount of refund has been mentioned. Now kindly see, after passing this order, an exhibit P7 was issued, where they entirely refused to give me the refund amount, and that is quoted by them 2,81,797. That is the last para of this annex P7.
इसको पढ़िए page 27 में, para 7,
27, annex P7,
page 27, para 7.
para 7. The assessee has not claimed relief under section 89(1) in original return filed on 27/10/2010 for accounting year so and so, but he has claimed refund of rupees 5,25,000. This was the amount which they had, which was deducted by the employer and deposited by them. Previously, I have totally recalled a whole amount deducted from the subsistence allowance salary paid for this and this. The assessee has claimed refund, but he has not claimed relief under section 89(1), which is mistake apparent on report, and relief under section 89(1), Act is allowed to the assessee. It was allowed later on. When I demanded the whole amount, by the 25,000, then they were ready to give me relief under section 89(1). Now 89(1) is for the tax paid for the arrears and in advance salary. Now they have taken 5,25,000 in advance, which is to be returned by them.
Again, next para padhiye.
Lordship, after this order,
Next para padhiye.
gross received by the assessee for financial year relevant. Now this is based on the papers I have given them. That is annexure 11. I have submitted in my rejoinder.
So this release that is due to you under 89
Kindly see rejoinder.
would be based on this 20,87,000.
Lordship, kindly see annexure P13 of my rejoinder. That is page number 5. Now this is the form ITS 10E of the Income Tax Act, which is to be filled to claim the relief of section 89(1). On this amount, on this form, number 1, the amount is clearly written 20,90,355. Now this document is submitted by me on their demand. Now kindly come to the next page. That is annexure 1. Here summary is given. Salary received in area, that is 20,90,355. A judgment that
Sir,
for that
already my lords have rejected this contention, my lord.
explain.
Already.
For that, I have given this case of.
No, we are
reported.
not forming any opinion.
Ji.
Let us seek the advice of the expert and then we'll come back.
In this case, the amount is judgment debt. It is not paid by them in due course.
All right. लिखिए इसमें. The matter is partly heard and is listed in the next week. पूरा clear. Next week, like.
Obliged.